Emergency vehicles in Ohio have been involved in more than 16,000 crashes over the past 5 years, and nearly 3 out of every 4 involves a police cruiser.
But 10 Investigates has found a legal loophole that allows cities like Columbus to routinely deny paying for damages when a police officer is involved in a crash. Here's Chief Investigative Reporter Bennett Haverly.
Passengers on this bus are about to be shaken up as a Columbus police officer crashes into them.
Open the back door. Just make sure he's okay. Open the door.
As passengers leave to check on the officer, the bus driver makes a call, stating it was the officer who failed to yield at a stop sign. At least one passenger who filed a claim against the city told us he was able to collect money, but only after filing a lawsuit. Initially, the city denied the claim, stating the city and the Division of Police were immune from liability, but acknowledged it was the City of Columbus Police who struck a COTA bus. The letter stated the officer was responding to a dispatch call of 2 small children near railroad tracks, claiming it was an emergency. That's a distinction we'll revisit later. But first, a pattern. And how much money did the city give you?
Nothing.
Nothing.
Nothing. At all.
This woman, who asked not to be identified for safety reasons, says she and a Columbus police officer collided last May, a crash which she says left her Toyota undrivable. She too got a letter stating the city and Division of Police were immune from liability.
It's not fair. It's not right. The police officer hit here. This is where he actually hit at. But when he hit it, it bumped all of this in the front.
A similar tale from April Glover. This police report states a driver who works at her medical transport company collided with an officer last August. The driver claimed the officer pulled out in front of him. April's company filed a claim. The city's response? This letter, stating the officer was moving his cruiser to block traffic for EMS when he struck your van, calling it an emergency call. To April, it doesn't make sense why the city would delay or deny payment.
The documentation is there. You know, we spoke with different people, and we still haven't gotten compensation.
Not $1.
Not $1. Not $1.
The whole bumper was hanging off. We had to tape it up because it was almost pretty much dragging the floor.
Elizabeth Jen says she was pregnant when a Columbus police officer rear-ended her last fall, damaging the bumper on her blue Audi. It's damage the mom of a now 8-month-old says she still can't afford to fix. The city's response to her request to pay up? They're immune from liability because the officer was responding to a robbery in progress.
Did he have his lights and sirens on?
No.
All told, 10 Investigates spoke to more than a dozen people who told similar stories of damaged property, getting denied, and having the city claim it was immune from liability. We also reviewed 108 claims dating back to 2018 where officers were blamed for either causing property or vehicle damage through crashes or other police work. In several cases, we found the city actually did pay up. But in 60% of the cases, the city said it was immune from liability, claiming the officers were on an emergency call. State law provides immunity for certain government employees, but defines emergency call as a call to duty, including but not limited to several circumstances. In its denial letters, the city has noted that Ohio courts have given them wide latitude to interpret emergency calls as any situation to which a response by a peace officer is required. We asked for interviews with both the Columbus Police and City Attorney Zach Klein, whose office decides whether these claims will be paid. Both declined. In a statement, Klein said this, quote, "While we understand why some residents impacted by these situations may be frustrated when seeking compensation, following the law in these cases creates a fair and uniform way each individual case is evaluated and prevents the city from picking and choosing who gets paid."
It's just inherently unfair.
Attorney Scott Bowman has represented clients in similar cases and lost when cities, towns, and counties lean on broad definitions to claim they're immune from liability. There have been recent efforts to change this in the legislature, but the current landscape can still leave individuals saddled with repair bills and crunched-up cars they can't afford to fix.
I couldn't believe they could get away with something like that.
Bennett Haverly, 10 Investigates.